Hey guys, let's take a look at what's going on in the Richard Allen case, which is pretty much everything that possibly can be going on. Earlier today, I was asking, is he going to have one lawyer, 0 lawyers, 2, 3, 4, but maybe now it's going to be like 7. Who knows, right? Let's get into this and take a look at the 2 filings that I've got that went up to the Supreme Court, which is the verified petition for writ of mandamus and prohibition, and also the brief in support of it. So we won't read all of the verified petition because some of it is duplicated in the brief, but we'll look at some of it. Okay, so what do we got here? Verified petition for writ of mandamus and prohibition, and that is asking the Indiana Supreme Court to order the lower official, the lower judge, Judge Gull in this case. And mandamus is to order her to do something, and prohibition is obviously prohibit her from doing something. So that's what they're asking for. And this is all couched under public access of court records, and that's generally what it's about. But of course, it's no secret that it's more specifically about the fact that she ordered the latest filings to be struck from the record and removed, and she doesn't want to consider them related to Rozzi's motion to stay in, or not motion, but notice that he's staying in the case, and then his motion to disqualify and continue the matters until her disqualification is resolved. And that's what he's aiming for. So this is the first shot. It's not the final shot in that. This is one of the most high-profile cases, these attorneys say, that has ever been seen for the Hoosiers. And it marks the first time they followed the workings, for many of them, the first time they followed the workings of an Indiana court. Yet virtually returned the access to court rules or access to court records. The rules have been violated, and then everybody's been left on the outside looking in. Instead of sunshine that public access is supposed to provide, the public and the media have been left in the dark. All right. And they're saying why they need it. But let's see what they're asking for. We don't have to guess what they want the Supreme Court to do. And let's go over that. And I'll tell you why. It's the first shot, obviously. A statement of precise relief sought. So they want the judge mandated to reinstate the following court records as publicly accessible documents on the chronological case summary and electronic case file. The Franks Memorandum. Remember that came and went, and we got a copy of it if you were interested in it, anybody out there, but it disappeared from public life in terms of a formal record. Then the verified notice of continuing representation. So that was Rozzi saying, I'm not leaving. The motion to disqualify, okay, you leave. And then a request to order for transcript and a motion for continuance. All right. Then they want her prohibited from ordering the removal of any court records filed in this case from the CCS and the electronic case file. It's interesting because different states have different levels of authority for a court to do that. Prohibiting the trial court from excluding from public access any court records without the requirements of the access to court records rules being satisfied, which certainly sounds reasonable. And that they're supposed to, if you're going to hide it, you're supposed to have an ACR form that identifies the specific ground upon which exclusion is based. I think she tried, or she has done this on a blanket basis. Unless everything in the court record is properly excluded, then you should have a redacted version and then the full version that's not public. And okay, that makes sense too. Mandating that the 118 documents on a zip drive be made publicly accessible in the CCS itself. Well, that was a mess, right? Everything had the same date on it and stuff. It's hard to find out what was what on that. All right, so this is basically what they want, and they're talking about that. But let's go back up to this part before we analyze the grounds that they have for this. Right up here in paragraph 1, you see what they want mandated, which is mostly the stuff about fighting over who's going to be the attorney in a case and who's going to be the judge in a case, right? So this is the mess that we've got now, and I think this is where the judge misstepped probably in how this was handled. If these guys were going to withdraw, then it really should have occurred according to the rules, which is in writing and on notice to the client. He doesn't have to agree with it, but he's supposed to get notice under the rule, and then you have the court action and not an oral withdrawal and a promise to later withdrawal. Is a very messy way to have this happen. Doesn't look good. And then on top of that, when he says, well, I decided I'm not going to withdraw, she says, well, I don't have to listen to you anymore because you told me you were withdrawing. So how's that going to work out? So we'll see. We will see. I'll point out on this. Look here on the bottom, Maggie Smith and some other lawyers are all popping in from Indianapolis on behalf of the relator, Richard Allen. And that just means that he's the person they're filing this on behalf of. So how about that? That's interesting, isn't it? So now he's got, in theory, Baldwin and Rozzi wanting to represent him. Maybe they are in the multiverse that we're in. And then the two lawyers the judge is appointing, trying to come in, maybe one of them has appeared, and 3 appellate lawyers. So there are 7 lawyers at issue here right now. So that's bizarre. And somebody says, which is a good question, has the investigation into the leaks been finished? Now, I don't know the answer to that, but there is some information in this brief. And so I want to get into that because that's where you'll see at least what we can know about it on a formal basis. Look at this award here, member for 4 months. That's awesome. That's a lot of tenacity right there. All right, so that's going to be the petition. I don't see the need to read the middle of it because it's duplicated in the brief. So let me switch over to that. Okay, here we go. All right. I could probably learn to do this faster. And there we go. All right. The relator's brief in support of petition for writs of mandamus and prohibition. So here's where the rubber hits the road, where they explain all the things that they say in the petition. Here's a comment that I think is good. Sorry for typos. There are way too many big egos in this case. The victims have been lost in all of this. So far, right now, yeah. And, if you're on the, hey, Richard Allen is innocent train, then he's kind of lost in it too. Okay, so if he didn't do it, having his case tied up in a bunch of procedural garbage and most of the documents, not just the ones about the victims, but pretty much everything has been excluded from any kind of ready access to the public. And now you got his lawyers halfway tossed off the case, and his case could get delayed. And for sure, whatever you think of him, he can't be blamed for the reasons why this is going on right now, because he didn't do any of this stuff. He didn't leak any of these things or expose it to being discovered by people that shouldn't and stuff like that. So on both ends of this, it's bad because it does take away from the idea that we'll have this trial and we'll see if this person is responsible for these murders or not, of these 2 young girls who should be doing other things in life right now. They should never. I mean, it's awful. What happened to them was absolutely terrible. So I agree with you there. When the procedure becomes the story, then the system isn't functioning well, and you can't. The judge has to look at how maybe she can do something to correct this, I think, because it's her show. She runs it. She's the judge. All right. So here's a table of contents. We won't go over it because we'll just go over it. Hundreds of documents are improperly excluded from public access is how they lead this. Now, remember, where they really want to get, obviously, from a strategy standpoint, is they want to get back on the record this motion to disqualify and Rozzi saying I'm still in the case, because then if the judge doesn't deal with that, they're going to head back up for another writ of mandamus, right? So that's what they want. They want that back on the record. And obviously that's straightforward, understandable strategy they're pursuing here. And they're dragging in all these things from all these past documents being potentially improperly excluded from public access to bolster what they're saying now and show that this is just generally being mishandled, is what they say. All right, so high-profile case, we all agree with that. And they're going back to April 5th, 2023, when Allen filed his emergency motion to modify the safekeeping order, and he marked it all as public, and then that was sua sponte changed to confidential and excluded from public access. And I would think that the safekeeping order is about where he was being held, if my memory is correct. So you could say, well, reasonable people ought to agree that graphic details of the crime scene are things that would, tread on the memory of the girls and are just salacious. They don't need to be out there. But what about the other stuff? So if this is about, hey, he should be in a prison or a jail closer to home instead of this prison he's in, why does that need to be out in the public eye if this is what that was? And there are a lot of things that don't relate directly to the crime scene or the crimes themselves that, you couldn't get at in this case. All right, so all of that was made confidential and the public couldn't get to it. And then 125 separate court records have been excluded from public access through the end of June 2023. But none of them include a mandatory access to records form to say, hey, this is why it's out. This is how it qualifies to be held out. As of today, there's no way for the public to know the grounds on which any document was held. Now, I agree that, say the leak or however it happened to the crime scene photos is one thing, and potentially disciplining the attorneys over that is an issue. It's a live issue. What they're trying to do here, of course, the appellate counsel, is to say, okay, but all the stuff has been excluded, and that's a blanket situation that you could, you can have discovery orders, protection of discovery, you can have confidential documents, you can have things withheld from the public, but there's a process to follow, and it doesn't mean that you just put the whole case behind a curtain, is the point they're making. And generally, I think that's a good point. So, all right. So then they say somebody tried to get access to these court records, and the trial court ruled on that motion, relying on that they were complying with the court order dated December 2nd, 2022, that prohibited public comment, commonly referred to as the gag order. And they make the point that that's extrajudicial comments are part of that gag order, and that generally is what a gag order is. So I see their point here, right? Yeah. I think obviously what they were trying to do, or at least in my opinion, early in this case, was tamp down how much of a public fervor there was over it. The first judge, remember, quit because of this. So, if you put it toward all the documents where nobody can see it, maybe they just will quit thinking about it. And that hasn't really worked in this case, has it? The trial court then allowed the parties to agree to exclude the entirety of certain records from public access. But those actions are prohibited by access to court rules. The court cannot exclude records otherwise accessible to the public because the parties agree to do so. Yeah, okay. Or because the parties have entered into a protective order. Right, there are rules for that. And unless everything in a document can be properly excluded, then you should have a redacted version. So if there's only a few things in a document, like maybe somebody's social security number, something like that, you don't put a black mark over the whole document like you're the federal government replying to a FOIA request. You're supposed to just mark out the secret part, confidential part, and then make the rest of it public. And then the court has available to it the unredacted version. I mean, every lawyer is familiar with how that works. All right. So then with regard to other documents that have been improperly excluded from public access, the trial court did not order the clerk to make the documents on the CCS public, something that clerks do all the time, which would have allowed the public to identify the filings they wanted. Okay, so this is when we did get that document dump. They're saying instead of just putting it up live like it's supposed to be, they created a special website situation here, AllenSuperiorCourt.us/Delphi/ and then you had this zip file of 118 documents, which was a tragedy. If you were trying to get information out of it, it made it a lot of work. All right, so they said everything was labeled the same, and here's what they're showing about that. So yeah. The actual chronological case summary in this case still has every one of the 118 documents excluded from public access, so they're not populated like they normally would be, even though they're not confidential anymore. So they're saying that's wrong. And then there are two more documents that remain excluded. They're not on the zip file. They don't have the form that you're supposed to fill out to hold back documents from the public, and never had a hearing, and that's some filing by the Carroll County Sheriff and a letter from a DOC inmate. Then this is interesting right here, right? More recently, on September 25th, the state filed a motion to exclude all future filings from public access until the court conducts an in-camera review of each filing, and the state then excluded even that motion from public access. The trial court hasn't ruled on it. And I think, the theme here is that part of the issue with the defense that at least some people are taking is that they are using the filing process, the theory that it can be public, to say things they really don't have any business saying. And that is a touchy gray area. I mean, they're the defense. They're supposed to be trying to do things. So, hold that as much against them maybe as some people do. Although I think, you could have redacted versions of documents that don't put people's names out in the public as I'm accusing this person of murder, and I'm using the litigation privilege to not be able to be sued for it. And I'm saying this person was responsible directly or indirectly for this murder. maybe you could have a public facing version of that document, but then say, Judge, we want to mark out things that can identify this person, keep that confidential. That would seem reasonable, right? And that would go with the not all or nothing theory that they're talking about. Allen files a frank memorandum of law, which he says which his attorneys have talked about how great a job they did on it. That's however you want to take that, but it is long. I think we can all agree on that. And, in my opinion, I think there's legitimate criticism that some of the names could have been redacted out of it. But I agree with the defense here that the whole thrust is that, that you don't throw the baby out with the bathwater. So the theory of what they're talking about in a case with other people, that identified people maybe that shouldn't have been. But there were also a lot of elements of that document to me that are more germane to a Frank's analysis, like, to the police, did they or did they not mislead the court with regard to, say, the witnesses that they have? Was the testimony that they relayed to the court a fair and complete version of that, or was it materially wrong? That doesn't say anything about the victims in the case or any other third parties or something like that. Why would that need to be confidential? So I see that they have a point in this, I guess, is what I am saying. So, of course, he filed the Frank's motion, the memorandum, and the exhibits list. That, I think, is all out there for anybody who does want to see it. So it's interesting that it's confidential. They said he filed it as a public document, but someone within the court excluded the 136-page motion altogether with no notice to them. Now, this is where, this thing is really aimed at here, which is the trial court attempts to effectuate the removal of Allen's chosen counsel over his objection without his consent or approval. And that's the wildfire that is really burning right now. In early October, counsel for, and this is going to talk about this, at least one of the alleged leaks, right? In early October 2023, counsel for Allen learned that Mitchell Westerman, they say, had surreptitiously and without authorization photographed crime scene evidence in this case that was being stored in Allen's attorney Andrew Baldwin's office, and then disseminated those photographs without Baldwin or Rozzi's knowledge. So I don't know if this guy did this or not, but here they are saying he's the one who did it. Attorneys Rozzi and Baldwin immediately informed Allen of this, and Allen said to the trial court, hey, I know this happened, but I still want these attorneys to represent me, and that it's in my best interest. And you can see this letter here, which I seriously doubt that he personally wrote, but I wouldn't doubt that it expresses his sentiments. So I think that's fine, because somebody might go, look, obviously his lawyer wrote this, and that happens a lot. So there's nothing nefarious about that. He wanted to keep them as his lawyers, so I wouldn't necessarily blame him for that. And Allen's not the one, who was busting the rules if the rules were being busted. Now, again, just because he's not the one who does it doesn't mean the attorneys don't pay some kind of price for that, depending on what the orders are, what happened, and all those things. I mean, judges have authority to deal with that. And how it happened in this case, I think, is why we're in the mess that we're in, because it could have been handled differently. Rozzi and Baldwin also immediately informed the prosecutor and trial court of this theft. Okay, so now look at that. They say because I wondered about this, when the judge said, well, we're going to talk about other matters or recent developments. Is she reading the newspaper? Is she on Facebook? Like, how's she finding out about this stuff? Well, they're saying here, hey, we piped up about it. We told the prosecutor and the trial court, this is how this happened, and this is what happened, is what they're saying. So then the court sets a hearing, 2:00 on October 19th, which, of course, was a nuclear bomb event over there in this case. Despite Allen's express instructions to the contrary, the court on October 12th, sua sponte, ordered the attorneys to cease work on Mr. Allen's case and scheduled an in-chambers hearing for the 19th, before the hearing scheduled for 2. Now, this is a little weird, because they've made the point in other filings that we didn't know exactly what the scope of this was going to be on the 19th, so you're kind of harming us in that way. We should be allowed, as much as anybody else, to work on the case to prepare. I'm not sure what was being accomplished there, but without knowing more about it, this does support their theory that the judge was prepared to boot them off the case. Because if she was going to do something short of that, why would she be ordering them not to work on the case? So, yeah. And the 12:30 meetings not noticed on the CCS. And you don't know that that's fully nefarious. A lot of meetings with judges occur that aren't on things. But when material things happen, you should get on the record and deal with it. Anyway, prior to this meeting, Attorney Baldwin filed a memorandum explaining the circumstances regarding the photographs, and that he was snickered and abused and betrayed by the theft. But he also says nothing, and they claim this is more important, and I just don't agree with this. Nothing has been disclosed and won't be disclosed at trial or hearings. That's not fair. That's not the right way to pitch this if you were pitching it to me, but I'm not on the Indiana Supreme Court, and I'm not Judge Gull or any of these deciding people. But if what was leaked were the crime scene photos of these girls dead on the scene, which is what I've heard. I haven't tried to get those. I've seen the F tree thing, but not these other pictures. Then no, you can't say that. You can't say that was going to get disclosed at trial. I mean, it's often the case that those kind of pictures that aren't shown at trial, some kind of public trial where it's out there as a digital thing that people can look at. So I don't, if that's what was let out, I don't buy this statement here. I can understand that they're saying that, somebody basically stole it from them. And so there's a limit to how much they should be punished for it and what that limit is and all that. Everybody could have their own opinions at, but I don't buy that. It's not really a big deal. That's not more important than leaking it. The fact that something might be available. For example, if Alan were to plea out on this thing, there wouldn't be a trial and showing these pictures. So I don't agree with that. I'm sorry. All right. Razi similarly provided trial court with a letter outlining what happened. He closed the letter from Alan, stating he still wanted those guys as his attorneys, which I think is true. And Alan was not present in Chambers meeting. I guess that's not surprising. But again, perhaps there should have been a limit to how far things got in that meeting, right? And maybe that shouldn't have been the first day to have all this media there. The trial court read a prepared statement, they say, to Razi and Baldwin, accusing them of gross negligence in their capacity as Alan's counsel. Now, they give a list of what they say she alleges, but you can read this list and instantly know this is not the list that she had, or at least not how she presented it, because this is pure advocacy. They say the purported act of gross negligence includes efforts by the defense to level the playing field with a press release after the prosecution filed multiple releases. Now, it is their intent, I think, to level it or maybe to tilt it back on their side. That's fine and that's fair and that's what they should do. But I don't think it's fair to say to the judge, you were upset at us because we tried to level the playing field. Did she say that? She'd have to be really dumb to say that, even if that's what she thought. She might not have been happy with what they said in it or the timing of it, but this defense team does this a lot where they read minds and go ahead and put motives up for other people and what their intentions were and things. And it's not factual, it's advocacy. So this is not her. This to me is obviously not the judge's list, but the judge will have, the ability to say that. I guess what I'm saying about this is if you're allegedly relating facts, but you're relating a very slanted position, sometimes that can cost you in terms of credibility if you're dealing with people who are watching for this. And Supreme Court judges are the kind of people who watch for this. But it doesn't negate the point, nevertheless, that, about this hiding documents from the public and stuff like that, or whether they were improperly pressured and stuff, which is their main point, which is what they're going to say. That they filed motions to protect Alan's basic human rights. Yeah, the judge said, look, I can't stand motions to protect basic human rights. I'm going to guess that her complaint about that was something specific and not that. So again, this is what they're saying, but it almost means nothing to me. This is pure advocacy. Filing the Franks memorandum that the court believed contained improper statements. What were they, right? Like, was it the general argument, or was the fact that you said this guy murdered these girls or sent people to do it, and maybe you shouldn't have done that? Filing a tort claim notice. I don't know why the judge would be upset about that. And third parties unauthorized photographing the crime scene evidence, which was certainly something that was upsetting people. So anyway, those bullet points may reflect areas that the judge had concerns over, but they're not neutrally relaying them to the appellate counsel, in my opinion, although they're repeating what I think Razi said, but that's okay. They can see what the judge said she was upset about, and then the Supreme Court judge sorted it out. It's all right. They still have a basic point that I think is still there. All right. So then they're saying that the judge told them after she reads the statement, you either get out of the case voluntarily or I'm going to read it in the record and to disqualify you in open court. Now, I think I've said before, and I actually heard another attorney saying on Court TV or Law and Crime, I think it was Law and Crime, that you don't quit because the judge is going to bust you a new one in court and embarrass you and stuff. And I agree with that. But what they're saying is not only that, but it would have harmed their own client. Okay. And that would be a reason to give in, I guess. So they were shocked and they asked to meet with Alan, which they were allowed to do. And they did. And he said, no, I don't think you guys done anything wrong. And I want you to stay on my case. And I don't want the judge to take my lawyers away. All right. After speaking with him, they returned to chambers and told the court this and said this is an unconstitutional ambush of defense counsel without due process. Any withdrawal would be involuntary and under duress because the trial court. Then did they say that to her? You know, that would be a very interesting thing, because if you say to the judge that if I do this, it's involuntary and under duress, and that's in the transcript, that would kind of look bad for the judge, wouldn't it? Because it wouldn't look like they're really withdrawing so much, right? This whole thing occurring in chambers is not good. Anyway, she said, but if you don't do it, you'll be disqualified in open court, is their version of the story. They're in an impossible ethical bind. If they didn't withdraw, they'd be publicly disparaged. And this would not only cast them in a negative light, but also the merits of their client's defense. And that's, to me, the legitimate reason, if you have one, to do what they did in this situation, and not just I was going to be embarrassed or whatever. I wouldn't have seen them pull out over something like that, and I wouldn't put that on them. All right, so retaining the jury pool and harming the defense, yada, yada. So Baldwin, I guess, orally made his motion. Yeah, that's what they said there. And Rozzi informed the court that he would file papers regarding his withdrawal at a later date. So if you say you got to file your papers at a later date, have you withdrawn, or are you just saying you're going to withdraw later? And that can be a big deal in the law. If you've already withdrawn, why do you need to file something? And if you haven't withdrawn, then you're still on the case, and maybe the judge should be spanking you for lying to her or something like that, depending on what really happened there. But, it could be a stretch to say, well, he's already off the case, because that seems executory rather than executed. Allen instructs his chosen counsel to make filings on his behalf, and then the court orders the clerk to remove those filings, both from the chronological case summary and the case file, which was certainly hitting it hard. I think we can agree. Why strike all of it? Why not just say, well, you could say it's struck and leave it on the computer and say, therefore, I'm not going to be dealing with this. But I think she actually ordered that it all be removed. All right, so the notice informed of Rozzi saying I got to stay in his case. There were no circumstances in Rule 1.6 of the Rules of Professional Conduct which warrant his withdrawal. And he didn't agree with all the gross negligence and stuff. Okay. All right. He certainly was upset when he came out, so I don't doubt that he didn't agree with what the judge was saying in chambers. But what did she say is what we don't know. Allen wanted him to stay on. That's fine. And then Allen also instructed Rozzi to file a motion seeking the trial court's recusal and a motion asking for continuance because of all these unresolved pending motions. And in theory, I think there's some Indiana law that does support that if you have this motion to disqualify the judge, that should be handled before other pending things are handled. That kind of makes sense, right? If the judge does have a big issue, why would you want to conduct further business? And then get off the bench? You should get off first, or not. Go ahead and rule not if that's the case too. Clear that issue up. I think I'm with the defense on that. And then, of course, we know the judge said, "No, I'm not going to do any of that because you're not on the case. I don't listen to you. I'm appointing the other lawyers that I mentioned." So, let's see, original action. So now they got to convince the Supreme Court. Well, you should listen to this because writ of mandamus is pretty rare, and it should be, because you can't have anybody who gets butthurt about something that a judge is doing heading up to any state Supreme Court or federal court or whatever and saying, well, you need to come down here and fix what this judge is doing down here, because then the whole nation would stop. The whole system would stop. So there's special rules you got to follow. Make sure that you put the issue properly before the lower court. It has to be only certain things they're going to do this on and all that stuff. So they need to tell the Supreme Court why they meet that. That's what they're doing here. And so one thing is the trial court has to act contrary to an absolute duty imposed by the law. So, maybe the court's starting at 9:30 instead of 9 because the court's got some other things going on. The Supreme Court's not going to let you have them ride into town and say you got to be here at 9 in the morning this week. It's got to be something real. So if the trial court has failed to perform a clear, absolute, and imperative duty imposed by law, and they give some examples. Enforce court rules, effectuate the disqualification of a trial court. And I stopped here on footnote 6 and read that case because there was a writ of mandamus there where a trial court had stayed on a case when there had been an earlier disqualification and then an order saying I'm not disqualified, and that went up for mandamus, and they said, now you shouldn't have stayed on the case. So you can see some foreshadowing here, because if they're successful in the list of things that we went over earlier, the next thing they're going to do is say, now get off the case, and if she doesn't do it, they're going to ask the court to intervene there too. There's I think in Indiana law that you can request a new judge, period, like a peremptory thing, but I think it has to be done within 30 days. And then after that, there has to be this newly discovered ground, or, these other things like they're saying that they're saying she's exhibited bias and all that stuff. So they wouldn't have known to do this in the early part of the case, but now they do, is what they're saying. And that's how you frame that. Public trust and integrity of the judicial process. All right. So they are also saying that you really need to ask the trial court to rule on it in the first place. Okay. You can't come up to us if you haven't asked first, because then you're just wasting our time. How do you even know that the judge is going to disagree with you? And we need the judge to rule on it so we can say, well, here's the mistake. Maybe you didn't like 3 things, but you got 2 out of 3 because you did ask the judge. You don't waste our time. So you've asked the judge. And that makes sense, right? So, but what they're saying here is because the judge has said, I'm not going to listen to you anymore, counsel, that they cannot proceed. They can't get it in front of the judge any more than they're already tried to do, because she said strike what they're doing from the record. And I think it's reasonable on their part to say if we filed something else, you just strike that from the record. So see, so much hinges on, are they really off the case or not? Because if they're off the case and the new attorneys are on it, then they really don't have any business filing this thing. But if they weren't really off the case, then they do have some business filing this thing. And I think this is very shaky from what the judge has done. And they're saying it's impossible to do it, as I just mentioned, because the judge has said, I won't read what you write, and I'll just order it struck from the record. And then they go on talking about how important it is for the public to have access to everything, which I generally agree with that. Presumption of open records. Parties can't just agree to hide things, and that's the way it should be, although I think they did do that earlier in this case, but they're just not supposed to. And basically they're saying that, I'll get to the part here where we talk about it. Trial court continues to violate the absolute duties because she's striking things off of the CCS and not letting the public look at it. You can't do it. And they're giving an example because, like I said, it's different states handle when you strike something versus actually getting a clerk to take it out of the file. Those are different things in a lot of areas. And so they're saying, well, how does this really work here? Because believe it or not, it's not the same everywhere. And when something is struck doesn't necessarily mean that it's gone, but sometimes it can mean that it's gone. It really depends. But here they're saying that when something gets struck, it just means that the court's not going to pay any more attention to it, but that the clerk doesn't destroy the earlier copy of it. And if they're correct in that, that is certainly logical. And blah, blah, blah. They're saying what the rules don't allow is for the filings to be sua sponte removed or excluded from public access. Okay? All right. And they want it all back. And a lack of meaningful public access in this case, that's true. I mean, I think the argument that too much is hidden is true, because it's not all stuff that's, to protect the victims. It's just a lot. So, let's see if I got some comments on that. Wouldn't a judge have run this up the flagpole before doing all this? Well, it did. I don't think that happened. It doesn't appear that it happened to me. It appeared that, blew up in chambers. So in other words, she needs to be right. Because, for example, let's say they hadn't filed this writ of mandamus, but they just filed an appeal later. This case, if he got convicted and she's wrong, the whole conviction could be thrown out. And it's still all a big mess at this point. So there's going to be some serious litigation in this case, I think, before this gets resolved. Why go directly to the Supreme Court? I think because I didn't look it up, but probably the original jurisdiction for writ of mandamus is with them. Because, again, it's a very rare thing. I didn't go read what the original jurisdiction is, but I'm assuming that. And so I don't get the force her to hurt our client rationale. Now, in terms of, should they have walked into the courtroom and just made her do it? Let me make my point again clear on that. If the concern is embarrassing to us and I don't want to be embarrassed in front of people, the lawyer has no business and no right to pull out for that reason. But when they say that the concern is this would be harmful to our client's case, and so we have to make the less bad choice at this moment, then to me that is appropriate. That's a professional judgment that they make. And so if that's the reason, and that is the reason that they're saying in this brief, I get that. But there have been some people saying, well, they couldn't do it because it would be embarrassing for them. And what I'm saying is that's actually a very low view of defense counsel, that they would ride away from Richard Allen because they don't want to be embarrassed in court by a judge fussing at them. I think they were more dedicated to the case than this. And that is consistent with what they're saying in their brief, which is it would have hurt our client if we had let this hearing go on like the judge was intending to do it. And I kind of believe that because of, the way that the thing ended up. So I get where they're coming from there. So, all right. I got into a discussion there. And here it says in Ohio, disqualification motion goes straight to the Ohio Supreme Court since they govern judges. Yeah, and that's the interesting thing is every state has different stuff. So like here, a judge can rule on their own disqualification motion as long as they don't have to make findings of fact. And if they do, they should send it over to another judge, but that doesn't automatically go anywhere. But, then it could. And here it's saying the lawyers maybe didn't make the less bad choice. I think it's all unclear right now. And for one reason is even if they ain't gone to the Supreme Court over this, if issues are presented that can create a reversal of a conviction, then the defense side is winning if that's going on, right? Because if you're the judge, you want this case to move forward in a way that doesn't result in reversal. Judges don't like to get reversed, right? Well, if he's found not guilty, you don't have to worry about it. But if he's found guilty and you made a material mistake along the way, this conviction could be thrown out. And in theory, let's think if he did do it, then that's not justice, right? And it's only justice if he didn't do it. But the fair trial is supposed to decide that, not a procedural mistake one way or the other. So that's why I'm saying what I'm saying about that. So they made the best choice possible under their narrative of concern that the judge was going to say things that would compromise their client's case. Say even if there were new lawyers coming on board, just the potential effect of what the judge might say. Because I don't know what the judge is going to say, but under what they're reporting, I can't argue against that. All right, so let's go. Get back down here and scroll. And the zip drive was terrible. Hard to argue about that. And then in conclusion, if there was ever a time when the openness mandated by the trial rules and access to court record rules was critical, it is the present case, one of the most high-profile cases that this state has ever seen. For many Hoosiers, this is the first time they followed the workings of a court in this state. Yet the trial rules and access to court record rules have been repeatedly violated, leaving the public and the media in the dark. A writ of mandamus or prohibition is appropriate to ensure that going forward, this court's mandates regarding public access are followed without exception. Now, it appeared to me that the court had accepted this and then told the judge, basically the judge, you've got till, I think, November 9th or something like that to file opposing paperwork. So now you got, I think, in theory, the judge and the defense fighting in front of the Supreme Court over this. And what happens, right? So if the Supreme Court says, okay, you screwed up here, you didn't exclude these things correctly, and by the way, put all this stuff back on the record that these guys are talking about, now you got a live motion to disqualify. And furthermore, they're saying that Allen is saying he doesn't want and doesn't accept representation by the two lawyers that the judge is appointing. So, what's happening tomorrow? If nothing happens, then I think you can understand that the judge has seen that this thing has gone to the crapper, and she needs to regroup. That's the most likely thing, I would think, there, whether she's right or wrong. And again, I think it depends to some degree what was said in chambers here. And I guess, I don't know what all they did or what all anybody's done or whatever, but taking the attorneys off the case is pretty much a super extreme thing to do. And I would not have wanted to see it go that way. It was coming up for trial in January. And that's why I say if they had done this wrong thing, it seems to me everybody could have sat down and said, look, let's start doing this like this. And this is the second or third time you've done something I don't like. I'm going to do something to you or whatever. Because again, Baldwin said, dock me 24 hours. So pay. Now maybe 24 is not the right number or whatever, but he was putting something on the table short of leaving the case. And the judge had those options. Now, she may have some information that totally justifies what she's doing or the choice that she put to them, even if it wasn't executed well. How do we know? I don't know that. But now the court's business is going to be put out into the sunlight, I would think, a little bit more, because there has to be some kind of response to this thing, unless she's just going to come off of the case and put a new judge on who makes all this stuff public and agrees to rule on these motions. Might be the way to short circuit all of this. But is she going to do that? I don't know. So I think all this comes back to a conservation officer's report not being seen by the right people. This case had never been heard of, and the bridge guy would be in prison. Yeah, so the thing is, as we watched the Dateline about the zombie hunter and how they had that right guy in their file for years and years and years until they got the family genealogy person to figure out, hey, here's his last name. And then they go look at it and they're like, how did we miss this guy? Sometimes investigations are screwed up, and then when they go back and look at it, they get the right guy. And then sometimes that's not the case, right? Sometimes maybe it's not the right guy. Now, I guess from a standpoint of trying to pick the simplest way out of things is, let's say Richard Allen is not the right guy. I don't need to think that there's a statewide conspiracy of odious to try and frame him for this to protect odious, because I actually think that's an ineffective way to protect odious. Because if that's what you wanted to do, you could have blamed Ron Logan because he's dead and he lied about his alibi, and the FBI looked at him and all these things and said, look, he's highly likely the guy that did it, but we'll never be able to prove it because he's in the grave now. We can't get more evidence and stuff like that. It was on his property. Then the odious, they're never going to trial, and you just don't really have to deal with it. Picking Richard Allen and to come back out of nowhere over this old tip and this, this forensic evidence, which is going to be highly contested, but isn't anything physical off his body at the scene, is asking people to go, are you sure you got the right guy? And so it's not the greatest way to protect odious, I think. That's my opinion. Now, having said that, if they have him and he's not the right guy, but they think it is, sometimes law enforcement gets a hard head and they won't go back and consider other theories, or just realize maybe this isn't strong enough. Now that I could see as a motive for agreeing with some of the defense's theories more than it's a giant conspiracy to protect people, because I don't buy that one. But anyway, that's getting back to the facts of the case and what do they got to do with this case, because right now it's all just a procedural nightmare. Let's see. Yeah, I mean, they could have pinned it on Ron Logan and Keegan Kline. It would have been a little harder to do because he's still talking. But how suspicious was that dude with that Anthony Shots account and all that stuff? Okay, I hear you here. You can't win an election on a guy that died and blame him on a whole election debate was based on the crime not being solved. I hear what you're saying. On the other hand, you arrest a guy and now look at the show you got now. If this is how it is, it's not so impressive, and maybe you don't win the next election or whatever. So clearly to get a Valhalla, you murder little girls. All right. And so that's what we're working on, is this whole Norse paganism video that we're working on with some people who know a lot about it, because I wasn't an expert on it, and I won't be even after we conclude this. And I don't believe anybody else is either. And it's very easy to accuse people of who don't share your beliefs of, being willing to just murder these two girls. For example, if the F thing that I saw is the correct picture, then I don't think there's any F on the tree. That's just my opinion. So, but again, oops, sorry, we're discussing facts of the case, and those don't really matter at this point. This is all about procedure. It's hard for me to think here that the judge didn't screw this kind of up a lot in how this went down. That if these attorneys, and you know these attorneys are serious on this case with the effort to put into it a kind of semi-casual way to handle it in chambers of, well, he orally withdrew, and that doesn't comply with giving your client notice and the rule of filing a motion and stuff, and this guy will do it later, and that's how this ends. I think it would have been better to say, if you mean it and you want to withdraw out of this case, then I'm going to postpone the hearing today. We won't tell anybody anything. And then you guys file a motion within X days, and then I'll consider that. If you don't, then I'm going to proceed with what I'm going to need to do, and then do that. And then everybody could have had this fight the right way, instead of wondering, how many lawyers does Richard Allen have tomorrow? Does he know? Can anybody really know? I don't think the law is so clear on all this stuff because this situation is so awkward. I mean, how are you going to find a case directly on point for this? But I don't bet on these things. But right now, if I were putting the odds on it, I'd put the odds on that if this case goes to trial, it'd probably be somebody else there doing it. Anyway. And here's a question I got here. If you'd be willing to answer it, I'd appreciate it. You say, I don't appreciate my slant. So how am I slanting this? That would be my question here. Especially since you're saying there's a lot of wild conduct and the judge seems out of line completely. I mean, I'm saying I think she screwed it up. Now, if my slant is that I can't know that, and I'm not going to credit everything the defense says as absolute truth because I don't know what was said in chambers or even all of what happened to judge all of this. I can't know that, but I think she did screw up here and has exposed this case to a problem. And I think, when I say that if I were putting odds on it, I think it'd be somebody else handling the trial. I think you can kind of see what I think about how this all ended up. But it doesn't mean I have to believe there's an epic conspiracy. I think there can be egos involved and some poor judgment. And listen, just because the judge screwed up does not mean that the defense is angels and everything they've done has been fully appropriate. They don't deserve any criticism for anything they've done and all that, because I don't think that's true either. But I don't think they should have been thrown off the case from anything that I've seen. Nor does it mean that I think everything the prosecution is doing is correct either. I think from the start, a lot of the warning documents sealed and things like that, I don't agree with that. And it did turn out that the probable cause affidavit didn't support, for example, the multiple actors thing. So there was some argument early on about, well, that somebody else may be involved in this, so we need to keep this all confidential. The only thing that was really being kept confidential out of that PCA is you don't have any evidence of whoever else might have been involved in this. So if there was somebody else, then they could go, whew, man, they don't have anything on me, I guess, because they didn't see it in that PCA. So I said in the last stream I did on this when I think Saturday, I don't think anybody's covered in glory in this thing. And there's rarely any time in life when somebody's totally perfect, but you can see it a little bit sometimes on some of these cases where once a side you're on, and then you tend to view how their lawyers or whatever are doing, and that's great. And the other side's terrible and the judge is evil. It all depends on which side you're on. So that's what I think about that. But I think, if you try and look at the whole picture, then you don't know everything that's going on right now, but from what has happened, these guys are dedicated to the case. So it strikes me as likely that they felt pressured to come off of the case in the way that happened, and that it was not handled appropriately. That's what I think about it. And so I think Rozzi probably really ought to be on the case and not addressing his filings seems, eventually, I don't know how you dodge it, but I could be wrong. Maybe the Supreme Court will go, nah, this is all totally correct. And then, we'll have to see how they say that, but it looks like a giant mess and I just think that's bad for the victims in this case, their families, and also bad for Richard Allen because this thing was going to trial in January, at least get to a conclusion and now look at it. But anyway, I'm not trying to slant it, but I also won't pretend that I'm not biased in it. Now my theory was that they probably have the right guy, but here I am saying that I think the defense are making really good points in this brief. I don't agree with all of it. Some of it's pure advocacy. You can look at it, but do I really think the defense thinks he's innocent? Well, sometimes, of course, you're going to see lawyers saying how innocent their client is, and they're They either don't care that they're not telling the truth, or they're just lying when they're expressing that so clearly. Okay. And they're not the only people that lie. I don't mean that. So, but what you got to say is, when they say it, do they really believe it? I wouldn't be surprised in this case if they do. They have been extremely emphatic about it, right? And they, if you're on the Allen side, then you see, you're not going to be persuaded about the bullet found in the ground. You're going to say that that's too marginal. And, you know, I know some people call it junk science, and that's fine. Then of course you're going to ignore it, but you can even acknowledge that it could have some probative value, but then you can also say, but it's not going to be enough. And yeah, he was out at the bridge, but there's no way to say that other people weren't out there too. And if you haven't really excluded all these other people, how can you say that that's him? I get that. And then of course, if you're thinking he's guilty, then you look at the odds and it being somebody else when you look at the eyewitness testimony, and all of that needs to be clarified really, I think, by the trial, seeing what the credibility is of the various pieces of evidence there, and the defense coming with what they find. They've put some of it out in this brief. So, I mean, it wouldn't have surprised me if Keegan was involved in it. It kind of surprised me he wasn't. So, and the same thing you could say about Ron Logan, and maybe say there's too many predators around there, right? So, and here comes Richard Allen, who, to my knowledge, has never been no one's even come out of the woodwork to say, yeah, he's really creepy. He was always messing around with young girls. He just never got caught. And sometimes you do see that with people like this. And I haven't seen that with him yet. He was drunk or whatever and stuff like that. But that's different than showing any kind of, affinity towards young women, inappropriate. And a lot of times these kind of people have precursor crimes and things that they've engaged in. Either they've been busted on, or they're people who know about it, start talking about it. So I don't know. That's why I try and respect both sides' opinion on this, as long as it doesn't go completely stupid. And, the video was planted and the girls brought it on themselves, and kind of like the Koberger thing, saying that the roommate stabbed him and stupid things like that, that his defense isn't saying. There are reasonable criticisms of this, very reasonable criticisms of this case that logical, intelligent people can bring. Even if you think that he did it, you'd be making a mistake not to respect and address the thought process of the people who challenged the case. What part of NC? Well, I'm in Raleigh, but I was in Winston-Salem for a long time. I don't know about all the coercing either. There's so much unknown stuff here. And we don't know what he said, and his wife keeps showing up and stuff like that. Yeah, Allen seems like the guy nobody suspected. Well, the thing is, they had so many people there who were horrible actors, and a lot of them look like the damn posters that they put up of the bad guys, the bridge guy, the two different versions of the bridge guy, which can be the same guy depending on how you're looking at it. But they all kind of look like that. There was that one weirdo, I don't remember his name, that they ended up ruling out, who was horribly violent. And his family was like, oh yeah, he easily could have been involved in it. Then Klein, with all the nasty stuff he was doing. And Ron Logan had a history of violence with women. His phone was alleged to be in the area around the time, and he lied about his alibi for the time when the girls were being murdered, and they were found on his property. And you can't look at the bridge guy video and go, well, that's certainly not him. And so, I hear all of that. So, I mean, I only hope that they get to the truth at some point. Now, in terms of this DNR officer, if this case were to go to trial, he's going to need to get on the stand, okay? And you can see some cross-ex there, and right? And I think that's important. Isn't that the point of the trial? Otherwise, you could just hand the jury, give them all Reddit accounts and let them read what everybody thinks, and they could come up to a verdict. You actually need the witnesses and the evidence in there. And to some degree, have an open mind until that occurs, even if you have an opinion on the case. And if you do that, then I think it's more fun discussing it than if you just are absolutely sure. Or at least if you're sure, you can at least go, well, let me hear what this guy's saying, and I'll challenge what I think against that. All right. So I think that's it for all of this. So the defense has picked up some assets with 3 more appellate lawyers, and they're asking the Supreme Court of Indiana to order the judge to put things back onto the docket, including, which is most important to them at this point, Rozzi's representation and the motion to disqualify, and then they will proceed from there. They want that motion heard, and for obvious reasons. And we'll see what goes on with that. There's the facts of the case and the procedure of the case. They aren't always intersecting with each other. So, well, that's it. And thanks everybody for stopping by, and we'll see what happens in this case, see what happens tomorrow. I mean, if it doesn't get delayed, then that's also super crazy. Talk to you later. Bye.